Fubara from representing the 800 billion 2024 budget of Rivers. Now, Justice Joyce Abdul Malik in a ruling also set aside the earlier interim order made on January 22, directing parties in the suits to maintain status quo pending the hearing and determination of the substantive suit. Justice Abdul Malik held that a similar suit in the matter had already been decided by a sister court on the day the interim order was granted. That will be our first line of conversation. Now, the second will be, as seen in that article, the judge also held that the plaintiff's counsel, David Maduka, lost the opportunity that would have offered him to be heard when he failed to address the court on the propriety of the instant suit in the face of the judgment already delivered in a similar case. So we would try to understand what propriety means from a legal perspective. Also, the article reported that the judge in a ruling directed the parties not to take further steps. Okay, no, that's not it. Let's go down again. Justice Abdul Malik, who fixed February 28 to hear the application, directed that the defendants, which include President Bola Tinubu, Attorney General of the Federation, Governor Fubara, Rivers Assembly, Speaker, and the Independent National Electoral Commission be put on notice to respond to allegations raised. However, the 6 plaintiffs filed another motion ex parte, and in that motion dated January 24 and filed January 25, they sought an order granting an accelerated hearing in the suit. They also sought an order abridging the time within which the defendants could file all their processes, including the plaintiff's reply, and the court fixed the hearing for yesterday. Now, when the matter was called, Maduka, who appeared for the 6 elders, told the court of their motion ex parte. The lawyer urged the court to grant their 2 prayers. Now, maybe I should go back a little bit. The prayers, the plaintiff or plaintiffs were asking that the court should declare the seats of the 27 lawmakers who dumped the People's Democratic Party (PDP) for the All Progressive Congress (APC) vacant, among other reliefs. They also queried the constitutionality of a peace agreement which they alleged that President Tinubu made Governor Fubara to enter into with the immediate past governor of the state and current minister of the Federal Capital Territory, Nyesom Wike. They maintained that the said agreement signed on December 18, 2023 was not only illegal but amounted to an usurpation, nullification, and undermining of the actions and binding relevant provisions of the 1999 Constitution as amended. All right, so those were 2 prayers, and the court asked Maduka to explain himself, and when he stood up, apparently he could not answer the judge's question when the judge drew his attention to the January 22 judgment delivered by Justice Nwokocha. She said at the time the interim order was granted, there was a judgment which is on a matter similar to the present suit. The judge then ordered Maduka to address the court on the judgment which had already settled the case brought before her. Responding, the lawyer said he was unaware of the judgment. And so because of that, and the judge, the justice, gave a judgment. She said, therefore, I hold that the plaintiff and applicants are privy to that judgment, which barred the parties from acting contrary to the decisions of the court. She gave a judgment. Although Maduka stood up to explain that it was not deliberately avoiding addressing the court, the judge did not give him a listening here. So I've got Professor of Law. I've got Barrister Richard Nwokocha via the phone. It's good to have you on the show. Welcome and good afternoon to you.
Thank you, Claudia Kuru, and good evening, Nigerians.
Okay, so you probably must have seen that report. You probably must have heard about the story emanating from Justice Abdul Malik's court. Let's stick with the first one. I remember the last time we talked about this. The judge threw away the entirety of the suit based on what happened at Nwokocha's court, Justice Nwokocha's court. What do you make of that? Let's start from there, please.
Well, On the day Justice Nwokocha gave his judgment, it was the same day this Federal High Court under Justice Abdul Malik was also sitting and made the order it made, maintaining status quo pending between the parties in the suit before her. The suit before her had basically two prayers. One, the parties sought the position of the court on the validity, the legality of the agreement purportedly signed under the meeting convened by the president between the parties, asking the court to determine whether the terms of those agreements were not unconstitutional, whether they were not in violation of the provisions of the Constitution. And then second prayer, asking the court to refuse the representation on the grounds that doing so is a violation of Section 109 sub 1G, which is the provision on cessation of the tenure of assembly members, members of House of Assembly of State. So those were the two prayers before the court in that suit. In other words, whether presenting it before them will not be presenting it before non-members, since Section 109 1G has already taken place and they were no longer, in effect, they were no longer members of the assembly. So those were the things that suit sought the court, the original suit. But what transpired yesterday is that the claimants in that suit, the plaintiffs in that suit, filed another motion asking the court to reduce the time within which parties will respond to that suit and grant accelerated hearing so that this suit can be heard more expeditiously or faster to enable it to be concluded faster. Now, it was in respect of that second motion, because if you recall, when that order was made, the case was adjourned to a date in February, either 28th of February or thereabouts.
28.
Yes, 28th of February. So the court now, in handling the fresh motion that was brought by the parties, now drew the parties' attention to the fact that there was a judgment on the same day it gave the order it gave in the substantive suit, the main suit, in respect of which they brought the accelerated hearing motion, and asked the counsel, and as you properly said, the counsel informed the court he was not aware of that judgment and urged the court to stand down to enable him assess the judgment and address the court. But the court, in its wisdom, these orders are at the discretion of the court. The court felt that he's not addressing the court at the moment has robbed him of the right of further hearing in that matter. So the court decided to dismiss the application that they brought for accelerated hearing. And the court also went back to the substantive suit and the order it made and vacated the order it made for maintaining status quo and also dismissed that suit. So that's what the court did in the case. And what it means is that the court has dismissed the suit because it believes that it is dealing with the same thing that has been dealt with in Justice Nwokocha's judgment.
Well, why do you think the lawyer, the plaintiff lawyer was unable to differentiate? Because the last time we talked about this, you said there were differences. Why do you think
it beats my imagination? Because the two suits are not at all the same. Neither are they related at all. Good, you recall we discussed that on that day, and I did point out the fact that they were distinct. One was a suit in which the House of Assembly, led by its Speaker, brought a suit seeking to restrain the executive governor from withholding their funds, preventing them from sitting where they want to sit, preventing to restrain the governor from applying to National Assembly to take over the State Assembly. Yes.
Prof, let me pause you. We have a commercial after the commercial.
That's right.
Right back after this. Be part of the moment to remember with AFCON 2023.
staying tuned as we went in for the commercials. 28 minutes to the top of the hour. I am Kala Dakaru Batubo. This is Hard Facts on 92.3. I've got Professor Richard Nwokocha, Professor of Law, Rivers State University. And we've been looking at the recent court judgment from Justice Abdul Malik's court, Federal High Court. And it concerns the resubmission of the 2024 Rivers budget and some other issues. Welcome back, Prof. It's good to have you.
Thank you.
All right. Before we went in for that commercial, you were talking about the distinct nature of Omotosho's suit, or the suit before that was before Justice Omotosho's court, and the one that was before Justice Abdul Malik's court.
Yes, I was stating the distinctions that while one was filed by leadership of a faction of the Rivers State House of Assembly, which contained vast majority of its membership, seeking to stop and restrain other institutions of the Nigerian state from interfering with the functions of the House of Assembly and the sittings of the House of Assembly. The other one had a completely different objective. That one was filed by concerned citizens who, like the government, have responsibility to maintain the Constitution or preserve the Constitution, asking the court to determine that an agreement that they were concerned about was unconstitutional, and the court should strike it down. And secondly, that a content of that agreement, which is resubmission of budget before persons, that content was again unconstitutional because it was seeking to ask the governor to represent the state budget before persons who, by virtue of Section 109 sub 1G, are no longer members of the House of Assembly. In other words, that asking him to present it before them is asking him to present it before persons who have vacated their seats as members of the House of Assembly. So they are distinct suits. The parties are different, that is one. The main focus of the suits are different. One was a protective suit to preserve the rights and the powers of the House of Assembly from being affected by other institutions, such as all those that were listed in that matter. I think there were up to 14 defendants and all that. While the other one is dealing with a different things. So what do they have in common? There was a subsequent prayer that was added in the first one, which is to ask the governor of the state to nullify the budget that was presented by the governor of the state before the other faction in that suit, the other faction of the House of Assembly, as at the time of that suit. Now, that suit had nothing whatsoever to do with the status of the assembly members, which changed in between the filing of the suit and today that we are talking. So the content of the suit is what was prayed at the time the House was in factions. As at today, or as at the day the judge was delivering judgment, the status of the claimants or plaintiffs before that court had changed because they had willfully vacated their seats in the House of Assembly. And the processes required by Section 109, subsection 2, fully complied with. In addition, by the orders of a court, or with the orders and leave of a court of equal jurisdiction as that of Justice Omotosho. So the suits were distinct.
Okay.
Completely distinct.
Okay.
So if Mr. Maduka, the lawyer...
No, go ahead. I was going to ask
you. Yes, go on.
I was going to ask you about the lawyer.
Okay.
But since
I was saying if Mr. Maduka was unable to distinguish between them before the court, then unfortunately he failed his client. You may also want to say that it should have been fair to stand on the suit and allow him address the court, since the court wanted him to state what the difference was. So you could argue that the parties really didn't get a fair hearing, because the court should have given them, in his discretion, should have allowed them to look at the judgment it was talking about and address them. But those are matters that you can only react to by filing an appeal to say that you were not properly heard and that you were not given fair hearing, so that you ask the Court of Appeal to set aside the orders made by the court and ask the court to retry the matter or to handle the matter.
The judgment, or rather the actions of the lawyer, can it be said,
Yes.
can it be inferred that just maybe it is in tune with the governor's body language or the statement that he wants peace in River State, and just maybe the lawyer knew that the case would be stood down, and so he decided to act in the manner he acted? Can we argue in that direction?
Well, you remember that it's not the same parties, and so at the same time that they were in court before Justice Abdul Malik, the other matter was going on. So if he says, "Oh, I was not aware of it," first, it will be true, because if the court sat in the morning, when court usually sits, and these contradictory orders or these distinctive orders are made by the court, it means the court was sitting at about the same time. A party in one court would not know what was going on in the other court. And that's where the issue of whether fairness would have demanded that you give him the opportunity to say whatever it is he has to say. If you are not convinced, you go ahead with the orders you want to make. But the court in its discretion decided that there was no point to wait and hear him by standing down the matter for him to go and look at the judgment and come and address the court. So the court has exercised its discretion, taking a position which it's entitled to take in the circumstances before it. It's for the party, if the party is dissatisfied, to do the right thing or do what the law allows him to do if he's as a dissatisfied party. And that is to move up.
Can it be said now, in the eyes of the law, that the issue on vacation of seats, or vacating the seats of the lawmakers who defected, has been dealt with by a court, a high court? Can it be said?
No. That issue has not been dealt with by any of those two courts at all. This court would have had the opportunity to deal with it before he took the decision that, since the lawyer could not distinguish that, as far as it's concerned, it's dissenting, and it gave his discretional position or ruling. So it's not been dealt with at all. The nearest to dealing with it is the order that was made by a high court in Rivers State when it was approached by the other faction and informed that these parties have defected, and in line with Section 109, their positions ought to be declared vacant. And that court gave go-ahead to the assembly as what was left of the assembly. So go ahead and implement the position of Section 2. Subsection 2 of Section 109. So that's the nearest to touching on the defection. The two federal high courts in Abuja did not at all touch on it. None of them made any pronouncement concerning the status of the parties and whether or not, having defected, they are still members or not members, or whether their position is different from that envisaged by Section 109, subsection 1G. None of them has made any such pronouncement. Neither has any of them considered that.
All right, Prof, we have another commercial, so at this point I would have to let you go. But thank you very much for your time, the time you've taken to explain this very situation to us.
It's a citizen's duty. Thank you for the opportunity.
All right, thank you once again, Prof. To you listening, you can start sending in your messages, and my own angle to the conversation is this: can we now rest this case? And I think I asked him, and he said, "Oh no, the court has not yet touched on it. The court is yet to touch on it in terms of the vacating of the seats of the defectors." Moreover, I asked that question because you remember, Rivers CSOs have also gone to court, and they're asking for interpretation of Section 109. And it's really getting interesting as the days go by in terms of the political situation in River State. But can we rest it now so that we can have development? That's the question I'm asking. Do you think that the matter has been resolved? Because it might just look like, oh, you know what, The governor could have called his loyalists, his friends, his allies, and say, hey, let's drop all the cases. And maybe that's why I'm just asking, because I find it absurd to think that the lawyer did not know about the case in Justice Nwokocha's court, even if it happened, even if the court cases were happening at the same time. The news the next day, the social media posts about the political situation in Rivers State the next day, or rather, in fact, the next 3 to 4 days, people talked about that situation. So the question in my head is, how could the lawyer not know? How could the lawyer not have heard? How could the lawyer not have listened to the news? How could nobody have told him? But maybe this is just me insinuating and assuming that he was not, or that he was told, and all of that stuff. But then the question remains is, can we rest it now so that we can have the development? Remember, the governor did say that he's been distracted and he's sad, or he's saddened by the fact that he has not been given the ability to do what should be done for Rivers people, and he's not been able to give governance for Rivers State, by Rivers State, and of Rivers State. All right, we have a commercial coming up. When we come back, open season, you and I will look at this and we'll talk some more, so just stay tuned.